question, second case I move to is Excel Crop Care Limited versus Competition Commission of India, 2017, 8 SCC 47. Now, the facts of this case are a little complicated. It is not my subject area competition, so I'll take a little time on this, a little more time on this. What happened in this case was that the Food Corporation of India made a grievance that the appellants had formed a cartel and they were trying to do what is called bid rigging. They were giving bids in such a manner that the entire process was rigged. So suppose there are 5 of us who are there. We have decided that a particular tender will go to me, the second tender will go to Amit, the third tender will go to Nikhil. We have ourselves decided amongst us, and we have put bids in such a manner that I am lowest in bid 1, Amit is lowest in bid 2, and Nikhil is lowest in bid 3. But all these bids are much higher than what the price should be. In absence of any other bid, the Food Corporation realized that these people are, the petitioners and others were doing bid rigging. The question which arose for consideration was whether this bid rigging is a part of the Competition Act, because bid, actually the word expression used in section 3D was collusive bidding and the definition was bid rigging. So the question which arose for consideration was whether this collusion amongst us, 3 of us, would amount to bid rigging in the definition of Competition Act. The Supreme Court held that these 2 expressions, that is bid rigging and collusive bidding, were like a birds of the same feather. They are always together, and one will take color of the interpretation from the other. So this is a important the law point which arose for consideration and decision was as follows. Number 1, that whether expressions which are used together can give interpretation to each other, bid rigging and collusive bidding, whether they can be used to interpret one or the other. And the second and another important aspect of this judgment was, now the Competition Act provides that in case you are found guilty of violation of Competition Act, a certain amount of your turnover will be decided as penalty. For example, you hold I am guilty of bid rigging, then you decide what am I the punishment. So 9% of my turnover, suppose the turnover is 100 crores, 9% of it, that is 9 crores, will be imposed on penalty. Now the question arose that a company, suppose I am a company, I have 3 or 4 products. I deal with product A, product B, and product C of 100 crores. The Competition Act violation is only for product C. Whether the turnover should be for the entire company or it should be for product C. So I'm just repeating it again. Suppose I manufacture a product which is rice, wheat, and something else. Take another product. And I have done bid rigging for rice. Should I be penalized for the entire turnover or my turnover of the rice? Here the Supreme Court has interpreted, and this interpretation has subsequently been followed, I think, in once Rajasthan Cylinders case, that you have to take turnover of the relevant product. And that's where a judicial interpretation has gone forward, because the Competition Commission Act doesn't provide this. The Supreme Court has interpreted the words to mean turnover doesn't mean turnover of the company. Turnover means the turnover of the product which is being actually utilized by the company, which is a part of the Competition Act, or which is supposed to have done bid rigging. So this judgment you have to write if a question is asked on this, you will have to invariably refer to another follow-up judgment, which is the Rajasthan Cylinders case, because this judgment has been consistently followed. So what is tested is not what you have understood, but also whether you have checked the follow-up. So be careful on that. You will get more marks if you are able to write about the follow-up. Now, the third case moving on is Competition Commission of India versus Bharti Airtel Limited, 2019, 2 SCC 521. Now, this is the longest judgment. I'll try to summarize it. Just give me 1 second. So what happened here? Reliance Jio made a complaint against three telecom companies, including Bharti, Idea, and Vodafone, that these three companies had actually colluded with each other and were trying to defeat certain rights of Reliance Jio. They made a Reliance Jio made a complaint to the Competition Commission of India. Bharti Airtel, who is the appellant here, challenged the jurisdiction of Competition Commission, and their argument were very innovative, and it's a beautiful argument that they made. They made the argument that I am governed by what is called the TRI Act and the Tribe Authority or the Telecom Regulatory Authority of India and Telegraph Act. Competition Commission of India is a special law dealing with competitions. My act is a special law, which is a subject matter related law. Therefore, I will be governed by the TRI Act and Telegraph Act. There were two special laws. One is Competition Act, one was TRI Act. TRI Act being specially meant for telecom authorities will override the provisions of the Competition Act. This was a simple provisions, the simple submission, very beautifully argued before the Honorable Supreme Court. So the question arose before the Supreme Court, and this is the question of law which arises, is whether the TRI Act overrides the provision of the Competition Act. And if not, how can these two acts be reconciled or construed in a harmonious manner? So three principles arose for consideration for decision, and the Supreme Court held as follows. Number one, when two enactments governing two special laws or two special subject matters are being interpreted, an attempt should be made to harmoniously construe those enactments. So if you can harmoniously construe TRI Act with Competition Act, then that should be the best thing. Otherwise, the special law will override the general law. So in this manner, the Supreme Court held that the initial jurisdiction of deciding any violation will be with the TRI authorities. To that extent, the Supreme Court held that it will override the provisions of the Competition Act. So the application made by Reliance Jio at the initial level was held to be not maintainable. But what is important is this is how Supreme Court beautifully balanced the TRI Act and the Competition Act. It held that if the TRI authorities, that is TRI, TDSAT, etc., came to the conclusion that Bharti or Vodafone or that time Idea have done some illegal activities because of which that would result in anti-competitive practices against Reliance Jio, then Competition Commission will have jurisdiction. So how the Supreme Court actually balanced these two enactments was initial jurisdiction will be with TRI and TDSAT. However, after that finding, if something else remains, then it will go to the Competition Commission Act. So I am not able to find a follow-up. It's a very recent judgment of 2019. But in case there is, please do look up. So these three judgments, that is the first one, Coilo, Competition Commission, and the second one is Bharti. Now, all these are part of my note. I am going a little fast because I just thought that at the end, if you have any questions. Now, the fourth and important law, which we all know of perhaps, is the Indore Development versus Mohanlal's case. So just, I mean, we have gone over this new act and 24(2), but just to those people who are who want a little more clarity, it's very difficult to get clarity, but let me try to put it simply. What happened was in 2013, Parliament passed the new land acquisition law, 2013 Act. Section 24(2) provided that if the possession has not been taken or compensation has not been paid, and the award has been made 5 years prior to date of commencement, that is prior to 1/1/2009, then your acquisition would lapse. So to give an example, suppose you had an award of 2008, your possession is not taken or your compensation is not paid, then the acquisition would lapse. And if the government still wants your land, they will have to acquire under the new law where the compensation is much higher. This is exactly what Supreme Court, according to me, rightly interpreted in what is called Pune Municipal Corporation case by a 3-judge bench in 2014. So Pune Municipal Corporation held that if possession is not taken or compensation is not paid, the word is or, then your acquisition lapses. Over a period of 6 years from 2014 till 2020, large number of lands were released on the basis of this judgment. One of the three judge bench judgments had a doubt on the correctness of Pune Municipal Corporation case, and therefore the entire issue was referred to five honorable judges. Now, what did the five honorable judges decide? The five honorable judges decided that one, Pune Municipal Corporation doesn't lay down the correct law. Therefore, Pune Municipal Corporation was overruled. What it held on statutory interpretation, and again something which you need to see the follow-up of, is that though the statute uses the word or, that is disjunctive, the word or has to be interpreted as and. As a result, it will become conjunctive. So what is the consequence? The consequence is that the acquisition would not lapse only if possession of the land is not taken and compensation has not been paid. So to rephrase, suppose I have an award against my land of 2008, compensation is not paid or possession has not been taken. Earlier, it would have lapsed as per Pune Municipal Corporation judgment, but now it would not be lapsing because either if possession has been taken or compensation has been paid. So that's the basic sum and substance of this judgment. Now, a pitfall of this judgment, and which is now coming up, and which is my duty to tell you, is that what is happening is a number of cases were decided between 2014 to 2020. Suppose I had a land, I went to court, court held, yes, possession of Mr. Gaurav Agarwal's land has not been taken, his acquisition has lapsed. My land got released from acquisition by a Supreme Court judgment in 2015. I'm giving you an example. After 5 years, this judgment has come. Now, what is happening is in large number of these cases, the DDA or the acquiring authorities are filing review petitions saying that the judgment which had attained finality 5 years ago is wrong. And as per the Constitution bench, my land has been wrongly released. Please return the land back to the state. So I am not clear whether that issue has been decided. It was going on, it's simmering issue, which will have to be decided in some point of time. So if you're aware of some judgment which has decided this issue, please mention it. You will get more marks if I am the invigilator. Now, this deals with Pune Municipal Corporation case. Just give me 1 minute. Yeah, sorry. Now coming to the fifth case. That's a famous case where the Supreme Court Advocate on Record Association versus Union of India, 2016 5 SCC page 1. I am sure most of us are aware of it, but just to, sometimes it helps to just read them again and refresh our memories. So we are all aware that appointments to Supreme Court and High Court judges was being done under a judgment of the Supreme Court, which said there should be a collegium, which will make recommendations to the government. So for Honorable High Court judges, the first 3 judges, and for Honorable Supreme Court judges, it was 5 judges. In 2015, Parliament amended the Constitution by what is called the Constitution 99th Amendment Act. And it's proposed, or it's set up, I would say, what is called National Judicial Appointments Commission, NJAC. Now, how NJAC functioned was that it would have 6 members, Chief Justice plus 2 honorable judges, the senior most 2 honorable judges, Union Law Minister, and 2 experts who were to be appointed. So a 6-member committee was set up, and it was decided that if 4 people say that a particular candidate should be appointed as a judge, he would be appointed as a judge. This constitution amendment was challenged before the Supreme Court, and a 5-judge bench was constituted to decide this challenge. The question which arose for consideration was whether this constitution amendment violated the basic principle of independence of judiciary. So the argument for the petitioners, led by Mr. Fali Nariman, late Mr. Fali Nariman, senior advocate, was that the appointment of judges by persons who are not judges violates independence of judiciary. If the government has a role in appointment of judges to that extent that it can overrule the collegium, so-called collegium, then it will impinge upon the independence of judiciary. The argument of Mr. Mukul Rohatgi, who was then the Attorney General, was that independence of judiciary is a concept which applies after judges have been appointed. Namely, that the appointment can be by the government, but once they are appointed, they should be completely independent by ensuring that there is no reduction in salary, there is pension, there is they can't be removed without the impeachment, etc. So these were the two contesting arguments which were before the Honorable Supreme Court. The Supreme Court in a constitution bench held that in all judicial appointments, and that is the question of law which was decided, I'll repeat, in all judicial appointments, the judiciary would have to have primacy. So therefore, the NJAC, which took away the primacy of judiciary in the judicial appointments, violated basic structure of the Constitution, and therefore it was struck down, in the sense that NJAC Act was struck down. It was held that if the Chief Justice and the judges have recommended somebody, it can't be that their opinion is completely disregarded, which would have happened if NJAC was to make appointment. The second is most important question, again a very important question came into consideration, was that what would happen if this act is struck down? Will the earlier collegium system revive? To which the Supreme Court itself answered that yes, the earlier system would revive. It is also important to note here that in this judgment, the Supreme Court also held that if a law minister is part of the National Judicial Commission, it will violate the separation of powers doctrine. That is, it will amount to executive interference with the judicial process or judicial appointments, which is not what the Constitution, our Constitution, envisaged. So they interpreted the basic structure doctrine and said our Constitution is different from the American Constitution. Our Constitution gives primacy to the judicial appointments through the Chief Justice and now in consultation with other judges. Therefore, that can't be taken away. So this is a landmark judgment which has restored back the collegium system of appointment of judges. Now, moving on, the sixth case is Dheeraj Moore versus High Court of Delhi, 2027 SCC 401. Before I go into this case, it is better I explain one thing, which is the constitutional scheme is that Article 233 provides and still provides that you can be appointed as a district judge if you have a practice of an advocate as 7 years. That's a direct appointment. Now, in our judicial system, which you are all aware, in the district judiciary, we have what is called the judicial service and a higher judicial service. So there are judicial service means those are people who are magistrates or civil judges. And the higher judicial service has additional district and session judges, district and session judges, etc., etc. Now, some people went to court, including Mr. Dheeraj Moore. Dheeraj Moore was a judge in the Delhi Judicial Service in the lower judiciary, if I may call it, without meaning any disrespect. That is in the judicial service. He was, I think, a judicial magistrate or an additional civil judge. He said that I am entitled to be considered for appointment on the direct recruitment quota also. And he was allowed to take part by an interim order. And I think some of the others were also allowed to take part. And they actually succeeded. And some of them, in fact, were appointed as judicial officers in the bar quota, if I may call, which is 25% of the total service. The Supreme Court was then a 3-judge bench was constituted to decide this question. And the question which arose for consideration in Dheeraj Moore was as follows: whether judges who are already serving in the judicial service of the state, can they actually take part in the bar quota examination for the higher judicial service? So this was a simple question which arose. Now, the text of Article 233, if you have it in front of you or you can Google it, reads as follows. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. So the Supreme Court held that the subordinate judiciary, in the sense those who are working as civil judges or district as judicial magistrates, were in the service at the time when they are filling up the form or writing the examination, and therefore they were not entitled to be even considered for direct appointment as a district judge under the bar quota. So this is a very important decision which you must keep in mind, that there are two separate streams. If you are already in service, you can't jump the stream and take up direct bar exam for the higher judicial service. In fact, the Supreme Court directed that people already appointed should be reverted. Now, as a subsequent development, I think those British people have gone in writ to the Supreme Court, and Supreme Court has actually by interim orders protected their appointment. So, and that matter is pending consideration. So that is something which you may look up and write if this question comes in the examination. Now, the next judgment is natural resources allocation. That is a special reference of 2012 10 SCC page 1. So just to recapitulate for myself, our constitution is, I think, one of the few constitution, I don't recollect which other constitution has what is called an advisory jurisdiction of the Supreme Court of India. That is, the President of India, which would mean the central government, can seek the advice of the Supreme Court on certain questions of law. It is a matter of advice. That advice is not binding on the government, of course. As a matter of Supreme Court rules, any such advisory opinion is decided by 5 honorable judges. That is, any advice under Article 143 within bracket 1 is to be decided by 5 honorable judges. Now, the question which arose for consideration was, suppose the government wants to actually give away natural resources, be it coal, for example, iron ore, telecom sector licenses, licenses for development of any industry in a particular area, allotment of land for industries. All these are what are called largesse. The question arose is whether the government is bound to auction this. I mean, is there any other option available to government other than auctioning this as a matter of law? So these questions you will find are the questions which will refer. Now, what I intend to do is that I intend to read what the Supreme Court has held. So pardon me for reading. I'll read it slowly. Now, Supreme Court held as follows. It is my summary of what the Supreme Court has held. Auctions may be the best way of maximizing the revenue, but revenue maximization may not be the best way to subserve public good or common good, which is the requirement under Article 39 capital B of the Constitution, small b of the Constitution. So stopping here for a minute, Article 39 within bracket small b figures in the Directive Principles of State Policy chapter, where it says that the resources of the community should be organized in such a manner so as to subserve common good. So the Supreme Court has held that if you auction everything as a matter of law without any exception, it is not what is the Constitution requires. It may not result in common good. Now, you must also know that an interpretation as to Article 39 within bracket small b is pending your judgment before 9 honorable judges in property associations case. So something may turn on that judgment also. Right now, I'm not able to decipher what may come out of it, but that you must keep in mind so that it will show that you are aware of what's happening in the Supreme Court. Now, coming back, point B of this judgment is common good is the sole guiding factor under Article 39B of the Constitution for distribution of natural resources. The manner in which common good is best subserved would depend upon the economic and political philosophy of the government. So stopping here, giving an example, suppose the government wants to set up an industry and it wants to give land. Auctioning the land may not be the best idea. the government can choose not to auction this land and go for allotment of land to different people to encourage a particular kind of industries. For example, if your government wants to encourage handicraft industries, it can, instead of auctioning land, allot land to people who meet the requirements laid down by the government. This is in sum and substance what the Supreme Court has held. Where revenue maximization is not the object of the policy distribution, then revenue considerations may assume secondary consideration to development consideration. So suppose you have a area of the government, area of your state which is very poorly developed, you need not auction that land or the resources. You can actually allot it, or you can do some other methods to take care of it. And the last point was auction, despite being a more preferable method of alienation or allotment of natural resources, cannot be held to be a constitutional requirement or limitation for alienation of all the natural resources. Therefore, every method other than auction cannot be struck down as ultra vires the constitutional mandate. So this is something you must keep in mind. You have to look up follow-up. I haven't looked it up and see if there are some follow-up judgments on this. Right. So I've done with 7 cases as of yet. I'm running a little fast, but the attempt is only to finish by 4:40 or 4:45 so that I can take some questions if you have any. Now, the 8th case which I want to take up in some detail is Shreya Singhal versus Union of India. Now, if you are aware, Information Technology Act was enacted in 2000, which dealt with computers and things like that, with internet coming in, computers, and all became resource material, etc. This was amended in 2009, and Section 66 capital A was inserted, which provided for certain offenses. Now, if you have 66A, or you can just open it and read with me, I'm taking little stress on it because it's a very important judgment on any field of law which you want to use. So 66A reads thus: punishment for sending offensive messages through communication service. Any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has menacing character, any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will, persistently by making use of such computer resource or a communication device. Any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or the recipient about the origin of such message shall be punishable with an imprisonment for a term which may extend to 3 years and with fine. Now, just see this provision. It says any information which is grossly offensive or has menacing character. Now, these words are totally vague. I may find a message totally neutral, and somebody like you may find the message to be grossly offensive or has a menacing character. So if I send an email to you which I feel is completely neutral, but you may find it to be grossly offensive, you will promptly go to the police station, lodge an FIR against me, and I can be on a subjective satisfaction, be actually sent to jail for a period which may extend to 3 years. So therefore, two questions arose before the Honorable Supreme Court, whether this provision violated my freedom of speech or expression. Because today, if I say something, you will go and say it's offensive. Today, what you may say, I may find offensive, while you may not find it offensive, and I may go to the police station and lodge a case against you. So the Supreme Court held as follows, and permit me to read it because it is just that it's the words of the Supreme Court, which I do not want to paraphrase. The Supreme Court held that the public's right to know is directly affected by Section 66 capital A. The information sent can be annoying, inconvenient, or grossly offensive to some and not to others. Therefore, petitioners were right in contending that Section 66 capital A of the Information Technology Act offends Article 19(1)A of the Constitution. Thereafter, the Supreme Court considered whether the said provision was a reasonable restriction as saved by Article 19(2) of the Constitution. The Supreme Court held that section 66A was not saved by any exception of public order, as it was not an element of creating public disorder, which ought to be the essential ingredient for the offense it creates. Now, why this judgment I think is a landmark is what it has held thereafter. I'll read it again. The most important part of this judgment is that the question of vagueness of the provision was actually held to be one of the reasons that it was struck down. It was argued by the petitioner that section 66 is so vague that it would result in an accused being totally convicted from a crime which he hasn't committed. So in para 79, Supreme Court held as follows, and I quote, quite apart from this, as has been pointed out above, every expression used is nebulous in meaning. What may be offensive to one may not be offensive to another. What may cause annoyance or inconvenience to one may not cause annoyance or inconvenience to other. Every expression, even the expression persistently, is completely imprecise. Suppose a message is sent thrice. Can it be sent? It was sent persistently. Does a message have to send, say, at least 8 times before it can be said that such message is persistently sent? There is no demarcating line conveyed by any of these expressions. And this is what renders the section unconstitutionally vague. So the law was struck down also on the ground that it was so vague that you are penalizing something which was completely not delineated. Now, in paragraph 86 also, the Supreme Court held that it upsets the balance between the right and reasonable restriction. And it would have chilling experience on the freedom of speech and expression. So this is an important judgment on, because it takes the law forward and says that when you are making a criminal law, your law should be absolutely precise as to what is the act which will be the criminal, which will be considered as criminal. Now that finishes case number 8. Case number 9 deals with Municipal Corporation Ujjain versus VVG India 2018-5 SCC 462. Now I'll quickly run through the last 2 judgments because in the sequence of things, they are laying down general principles. So this was a case where Municipal Corporation Ujjain floated a tender for waste collection. It had a marking system and an expert which awarded the marks. BVG India, which is known, even the Supreme Court services are done by BVG, challenged this allotment of the tender in favor of the appellant. The appellant before the Supreme Court was Municipal Corporation Ujjain, but there was a private person who was awarded this tender. Now, the High Court set aside the tender awarded to the successful tenderer, against which the municipal corporation and the private person came to Supreme Court. The Supreme Court held, and these are the principles which we see following, that the interference with the High Court in award or assessment of a tender is very limited. What are the grounds on which the High Court can interfere are very, very limited, which is number 1, that it should not be such an arbitrary, or it should not a decision, and it should not show favoritism. That is, the decision should be not arbitrary. Just to repeat, the decision should not be arbitrary. It should not show that any favoritism has been done to any party. And it should be such a decision which no ordinary person would have reached in the facts of the case, what is called Wednesbury reasonableness. So therefore, these are the only 3 limited grounds on which your tender could be set aside by the High Court. Now, this judgment is my duty again to tell you, because the note said that there is a reference to the earlier judgment of Ramanna Dayanand Shetty versus International Airport Authority, that is 1979 judgment. Now, this judgment, this is Ramanna Dayanand Shetty, is a very important judgment because it holds that every word in a document, which is especially a tender document, must be given interpretation should be taken into account by the court while interpreting the document. It should not be that you just ignore some words or ignore some phrases, and it will result in actually doing violence to the law, or the violence to the contract, or violence to the tender. So the Supreme Court reiterated its judgment in Ramanand Dayanand Shetty and said every word in a contract or a tender has to be given effect to. This is what the Supreme Court has held in Municipal Corporation Ujjain. That is parameters for interfering with the tender, and that you must take into account the tender every word, and no words are to be removed as surplusage. The last judgment is Sangyong. Now, Sangyong judgment versus NHAI is very important for two reasons. Because, as you would know, the arbitration award is challenged. There are very limited grounds on which these awards can be challenged. One of the grounds which was inserted in the 2015 amendment to the Arbitration and Conciliation Act was that the award should not breach the fundamental policy. Sorry, I'll just read the expression. The amendment was that that it should not suffer from one, patent illegality appearing on the face of the award, and secondly, it should not be in breach of the fundamental policy in Indian law. So these are very high thresholds which has been kept by the law in interfering with the awards. So the Supreme Court held, number one, and three principles. Appreciation of evidence is not possible in a Section 34 challenge to the award. Number one. Number two, construction of the terms of the contract is for the arbitrator. If the view of the arbitrator on the construction of the terms is a permissible view, then that award will be upheld. And the award can be set aside only on few grounds, namely when the finding is perverse to the extent there is absolutely no evidence in support of the award. Now, these are principles which we all know of, but what is this judgment, I believe, is very important here. What happened here, and therefore I'll just dwell on it for a minute, that two arbitrators gave a majority award, which was partly in favor of the appellant Sangyong. One arbitrator, who was the dissenting arbitrator, gave the full award in favor of Sangyong. The Supreme Court came to the conclusion that the majority arbitration award was actually incorrect. Therefore, the consequences would be what? It would have to set aside the award and actually send the matter back for fresh adjudication. But what in paragraph 77 the Supreme Court does, and that you can remember in future, is, I'll just read it out for you. The judgments of the single judge and of the division bench of the Delhi High Court are set aside. Consequently, the majority award is also set aside. Under the scheme of Section 34 of the 96 Act, and this is important, the disputes that were decided by majority award would have to be referred afresh to another arbitration. This would cause considerable delay and be contrary to one of the most important objectives of the 96 Act, namely speedy resolution of the disputes by arbitration process under the Act. Therefore, in order to do complete justice between the parties, invoking a power under Article 142 of the Constitution, and given the fact that there is a minority award which awards the appellant its claim based on the formula mentioned in the agreement between the parties, we uphold the minority award and made it the majority award. Now, this, of course, the Supreme Court has done under Article 142 of the Constitution, but it just shows that if the Supreme Court didn't have a minority award, one would have to go back and have a fresh arbitration. So that completes my 10 cases, and this note will be circulated to you. Any questions you may have, please feel free to ask them.
Sir, thank you so much. So now I could see there are no questions being asked by any of the aspirants, but there are two questions, like should generally be written.
Yes.
So that's a very important question being
Sorry,
asked.
I missed your point. What did you say? Sorry, the voice is broke at the... I couldn't hear the question you had.
No, how many pages one question should generally be written?
All right. So I actually wanted to tell, it's something which I keep telling all my friends, and I've been telling them for last 20 years. I do assess some of the answers for not the AOR exam, but there's also an exam for interns who become law clerks. So I believe as an invigilator, three important facts you should keep in mind. Your handwriting should be legible. Okay. So it doesn't make a difference whether you write 3 pages or 1 page. Whatever you write slowly, because we are not used to writing at all. This AOR exam is exactly a test in your writing skills more than your learning skills. So please write legibly. That is most important. Number one. Number two, just step back and give thought to the answer before actually you start writing. It will help you actually save a lot of time. If you say, what do I intend to write as an answer to this question, isn't it? So don't immediately start writing. Just take 30 seconds and restructure your answer that, yes, this is the question of which I have been asked. This is my answer, and I want to restructure this in this manner. Now, as far as how long the answer should be, I think you should work this way. And this is, I keep telling everybody whom I meet. Suppose you have 10 questions. You have read those questions, and I'm assuming that you can answer 10. And you have 10 minutes per question to be answered. Suppose I have 100 minutes and I am given 10 questions. I'm assuming I can answer all of them. I will divide my time straight away into 10 minutes. If in 10 minutes I can write one page, I am happy with that one page, right? So there's no point spending 20 minutes in a question and missing out on 5 questions, and actually writing lesser. If you feel that I know only this much, please write that much and move ahead and move to the question where you know a little more, you think, so that you can score better marks. So it's a question of strategy. It's a question of strategy. When you get the question paper, you would know that I know answers to 5, 6, 7, 8, or even all 10 questions. You would know that I know the answers to question number 2, 7, and 10 very well, right? So you have to score 50 marks or 55 marks, right? That is your aim in life. Your aim is to get that minimum, I think is 60 marks, right, Amit?
Yes.
60. So assume I have 10 questions. Each of them carries 10 marks. I'm assuming against myself. My goal is to somehow make it to 60. My answer should be that if I know 7 questions very well, I will quickly complete the other 3, which, I mean, if you go seriatim, I don't know answers to 1, 4, and 7 well. I'll write some short thing for 1. I will focus more on the questions which I know. So I think that is very, very critical, that you plan that you have to get those 60 marks. You don't have to write a thesis. You don't have to impress anybody. Your only aim in life is to answer questions in such a manner that you get 60 marks. So I think that should be the attempt which you must do. So take a minute, read the questions, identify the questions which answers you know very well. If you don't know the answers to some questions, you can actually skip it. You can write a shorter version so that you don't waste time on it. Spend time on the longer ones. Just give a thought on how you want to structure your answer and write legibly. Even if you write half of 1 page for every question, I think I am very happy with it, as long as it shows that you have read the case and you have understood what the case is all about. Now, how to structure an argument is a paper will depend on what the question is. But if I am the invigilator, I would look for only one thing: whether you have understood what is the question of law which was considered by the 9 judges, 5 judges, because most of these judgments are by 9 judges or 5 judges, except say Sangyong and others. So you will have to very, very clear, mug it up what was the question of law referred, and succinctly lay down what was answered. After that, it depends on the nature of the question which is asked. I think that is most critical.
Thank you, sir. So now I would like to call Mr. Amit Sharma, our Vice President, to give a vote of thanks.
Good afternoon, everyone. First of all, let me thank the EC for giving me this opportunity to give the vote of thanks. For me, Mr. Gaurav Agarwal is one of the most deserved designated as senior advocate by the Supreme Court of India. That was on 19th of January this year, 2024, before which he has put in as 19 years as an advocate, or nearly 19 years. 5th of May 2005, Mr. Agarwal became an AOR. So besides for me, he's been an elder brother for all of us. He's been instrumental in assisting the Honorable Supreme Court in many important cases in his capacity as a practicing lawyer. Also, most of the cases he has done to assist the court, which has actually been remarkable. Some of them are like, one of the very important case was with regard to the advocate on record, where the court wanted Mr. Agarwal's assistant to ensure that AOR does not become a merely signing authority, etc. So that was one of the remarkable and very landmark cases. I think it's still pending. There was another case where Mr. Agarwal's assistance and was sought by the Honorable Supreme Court, and which was that, if lawmakers can claim immunity from prosecution for taking bribe. These are some very important. The list is endless. He's been the best friend of Honorable Supreme Court of India for a long time. So we can safely say that. I would extend my warm regards to Mr. Gaurav Agarwal on behalf of the entire EC SCAORA to have delivered such a valuable and comprehensive lecture on leading cases, which surely will benefit all of us, including the aspirants who are due to write the paper in June. So I extend my gratitude to Mr. Agarwal, and I also wish all the AOR aspirants who are preparing hard to give their exam. So our best wishes from EC SCAORA to them.
Thank you. Best of luck, everybody. Thank you, Amit. Thank you, Nikhil.
Bye.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Bye. Thanks.